Ayubowan. Welcome to Sarva YouTube channel where we bring you everything simplified. Today we will be starting a new series of episodes where we will be talking to you about public international law. I am Siddharth Gajanayaka
and I am Sahan Dharmasena.
And both of us we will be talking to you about this very fascinating subject of law. So let's begin. So now for a start, I will start this discussion, Sahan. Now, what is public international law? How do we define public international law? So there are two words, Sahan, in this. One is public, the second word is international. So what is the meaning of public? Do you know any idea?
I think it means something along the lines of something that affects a lot of people.
Affects a lot of people, right? So I think that is somewhat correct. Yes. So then public, let's for the moment we'll keep it at that. But if we go deeper into this word public, you will see that public actually entails, the word public entails the fact that it governs the relationship, right, among many bodies, like you correctly said. So what are these bodies we are talking about in the context of public international law?
I think it mainly refers to different state actors
or countries or states. So that is where the second word becomes very important. Second word is international. Right now you might have heard, Sahan, we have this inter-school cricket tournament, inter-school badminton tournament, or inter-party agreements. Then so what does this word inter mean?
Between
or among between two parties or among many parties. So then when we say international, we are actually referring to among nations. National means nations. Law of nations. So another word for public international law actually is law of nations. So therefore we can see public international means the law among nations. So then the third word is law, public international law. So then what is this public aspect? Then one can ask, is there a private aspect as well? Alright. So is there a private aspect of international law according to your understanding?
There is, especially when it concerns two individuals or basically two or three
private matters. Yes,
between few parties.
But the matter has to be private. It's not something that will be of national importance to a country. So now, Sahan, now one can ask, is there a private version of this as well? Now, public is there. So public we just discussed that it refers to these broader matters, right, at a very superficial level. So then, is there a private version of international law as well?
Yes, Siddharth. Now, the private version entails basically a matter between few people, but that is of not national interest.
Yes. So now, for example, let's say there might be two parties, one from, let's say, India, another party from Germany, and these two get married, right? And let's say they get married in Australia. So there is an Indian, there is a German individual, and these two individuals get married in Australia. And let's say they are now living in Canada and they want to get divorced. Now what law is applicable? Is it the Canadian law? Is it the Australian law? Is it the Indian law? Or is it German law? So we run into a conundrum. Right? So this is the same now, for example, another area of law where this conflict is there is with regard to testamentary law. Let's say you are from Sri Lanka and then you go to Russia and you die in Russia. You have properties also in Russia. You might even have citizenship there. So then what happens to your properties? Who gets the properties? Let's say you have successors in Russia and in Sri Lanka also. So then can the Sri Lankans go and get those properties which are there in Russia, which were yours initially? So these conflicts like that only we discuss in private international law. So Sahan, you will appreciate that these matters are not of public importance. So now Germany or Australia or India is not going to bother about how two individuals got married and how they are going to get divorced.
Divorced in Canada.
In Canada, exactly, right? So their worries will be bigger worries, right? What sort of trade is going to happen among the countries? When is the next nuclear bomb going to be dropped? Problems like that. So there we can see they refer to macro problems, the countries. So these macro problems only are identified, the problems among nations. So the word given for that actually is the word public. That's why we say it's public international law. So private version entails So that's also another branch of law, just like we discussed. So that branch of law entails these private disputes, but which have an international dimension. So that is of course another discussion for another day, and
which we will get into
of
later.
course, hopefully. But for the moment, we are going to talk about public international law. So I believe now the definition is clear to all of you. There is public international law. So the law among nations. So then next we will talk about the difference between domestic law and this international law, right? Domestic and public international law particularly. Now one might also, now before I get into this discussion, one might also wonder whether public international law and international law are also the same, right? So actually speaking, international law can refer to so many branches of international law. There are so many branches of international law actually. So when we say international law, we are referring to all those branches. So for example, there might be international intellectual property law, international commercial law, then international trade law. So many, all the domestic versions of law we can actually expand to the international level and talk about an international version of those laws. So that is, so when we refer to the word international law, it means all of these aspects. So public international law is actually one
Aspect of
one branch of international law. So that is the branch that we are going to talk about. All right, now again another very famous, very active area of law is international human rights, right? So which is now a separate study on its own. You can even do a PhD in international human rights law. So these areas are now very advanced, and academics are studying these branches
separately.
Of course, we will be discussing on this one branch of international law, which is public international law. All right. So then let's talk about the differences now, as we were coming to that discussion. The differences between domestic law and public international law.
And I think for those of you who don't understand, domestic law is the law inside of your country, your host country, and in public international law is law between each country of its own.
So now one main difference, so if we start off, there are a few differences between this domestic law and public international law. So the first one is, now if we see, Sahan, in a domestic context inside your country, you will have a supreme legislature which makes laws. So if you look at the first difference between public international law and domestic law, we see that in the domestic context, the laws are made by a supreme legislature. This legislature has been given the powers, probably by a constitution, to make laws for that particular state or for that country. However, in the international context, we don't find this, right? So there is no supreme legislature which makes laws for the whole world. Now then one might ask, then what about the UN, the United Nations organization? So what do you think, San? Does the UN make laws for the whole world?
If you really think about it, the UN is made of countries from all around the world, and they do have different committees and different agencies to handle different parts or like different issues. But if you really look into it, the UN doesn't make laws. The UN makes agreements between countries that everybody agrees upon. You can sign a treaty and then you can ratify a treaty that we'll get into later. But if you really look at it, they don't make laws. They are not like some kind of like a supreme body, like a parliament. They are people that basically broker agreements.
Exactly. So they act like an intermediary just to get the countries together, get the countries to agree on certain aspects, so on and so forth. But they do not have the supreme power to make laws applicable for the whole world. But that is not the case if we look at, for example, the parliament, the Westminster Parliament in the UK. So the Westminster Parliament in the United Kingdom, for example, they have the power to make laws for the whole of the UK, applicable to the whole of the UK. So there we can see a clear difference between domestic law and public international law. Then if we see the second difference, it is the fact that in the context of domestic laws, we see that the basis of conformity, why someone subscribes to a law or why someone decides to follow a particular law is mainly due to coercion. Coercion means there is some deterrent which says that if you don't do this act or if you do this act, you will be punished. So it is based on this coercion that one would want to follow a particular law. However, in the international context, we see so many countries not abiding by so many laws, but there is no problem. So, however, the countries which are following the laws mainly follow it out of consent.
Consent.
They consent with each other. So, for example, Sri Lanka might give India certain goods, and India will accept those goods and pay Indian rupees or Sri Lankan rupees to Sri Lanka. So now there is an agreement there. It's a sale of goods agreement. So there you can see consent. So it's not that we are paying out of some fear or they are paying out of some fear. It is because it was agreed like that between the parties.
Basically, in the context of domestic law, you are supposed to follow the law because it matters to the society that is inside that country. Internationally, though, a fight between two people in a country might not be that bad, but a fight between two countries might be really bad. So all countries, now say I am from Sri Lanka and Sir is from India, we both agree on something in order to sort of mitigate a fight or to trade goods.
Exactly.
Right? And it's mutually beneficial for the both of us.
For both parties. So that is again another major difference. So also we'll give another small example so that one would understand. Now when we go on the road, we have supposed to follow so many road signs, and we are supposed to follow so many rules and laws as well. So now for example, if you are drunk and you end up driving, then chances are that you will most likely end up in prison or you will have to pay a huge fine in any country. Why? Because there is a direct threat of what you are doing to the society. And whether you like it or not, you are bound by the law. No one asked your consent when you are born, or do you want to be bound by the traffic laws of India? No one asked that question. By virtue of being born into a country, you are bound by the laws of that country. All the future laws also that might be imposed on you.
One can say it's simply the price of the citizenship.
Exactly.
That you are bound by that country's
laws. And that is why you also have the freedom to elect the people who are going to create the laws for you, who are going to make laws. So that freedom also you have because of democracy. So either way, this system of regulation mainly works out of coercion in the context of domestic law. But if we see the international context, we can't force countries, like in the context of domestic law, we can't force countries to do certain things or to not do certain things. The countries have to on their own, with consent, get into these sorts of agreements. So we see, Sahan, now there are famous examples. Now, for example, North Korea, they are not listening to so many countries. If they, so many countries have tried to cooperate with them, but they are not listening to, they are not amenable. But that's fine. That is international law. There is no way that you can literally punish North Korea for it. Of course, there are sanctions and all of that which can be considered as some form of punishment, but still, there is no physical punishment that can be imposed on the leader of North Korea, for example, under international law, unless, of course, he has
committed
grievous crimes and whatnot, which is an exceptional situation. But if not, merely for not complying with a particular agreement, or merely because that country is not following the rules and laws and regulations that other countries are following, you cannot punish a country. So there might be reasons why certain countries are not following certain laws. So that is all fine. So that's all part and parcel of international law, and we see that that difference is also something very important to know. So now the third point, the third difference is that in the context of domestic law, there's a judiciary which interprets the law. However, in the international context, we don't see one specific body like that which interprets international law.
Now, Siddharth, if you really think about it that way, what about if you take the ICJ, the International Court of Justice?
Very good question. Right? So, the International Court of Justice, you and I can't go to the International Court of Justice. It has to be a country which has a problem.
Another country.
Yes. However, the problem there is, now then still someone can say, yes, then there is a body which is like the supreme judiciary of the world. But no, if one country wants to take another country to the ICJ, they can only do so with consent of that other party. Now that is not like that for me in Sri Lanka. If I commit a crime, whether I like or not, I am bound by the orders of a judiciary. But that is not like that in the international context. Now, so many countries have gone to the International Court of Justice. judgments have been given, but some countries don't follow them. Best example, the case of Philippines versus China. So China did not really follow the verdict that was passed on them with regard to certain islands which were apparently owned by the Philippines.
And another good example would be US versus Nicaragua.
Of course, which we will be
US lost also.
US it was a clear violation of international law by the US, and they were asked to pay compensation, which they didn't. So there you can see a clear difference, but you can't do that in a domestic context. If you don't follow an order of a court, you will be jailed. You can be punished. There might be fines that you have to pay because you didn't follow a judgment. So it's a very different scenario when it comes to the international context. So there again we see a major difference. Then the last difference, of course, there are so many differences, but for interests of time, we will talk about the most important four. So the fourth difference that we have identified is that in the context of domestic law, certain subjects can be above the law. Right? They might be immune to certain laws. But generally, everyone gets treated equally. Now, for example, in a domestic context, a foreign officer might enjoy certain benefits that other citizens of that country don't enjoy.
The head of the state might enjoy.
The head of the state might enjoy. Now, in the context of Sri Lanka, even there are certain immunities which the president of Sri Lanka is entitled to by the constitution itself to receive. So that can happen. But generally, by and large, the population is treated equally and fairly by the justice system of that particular country. However, in the international context, is it the same?
No, the international context, it's very important. They consider all states as equal, which means to say, even if you were a third world country, your sovereignty or your independence is equally important to that of a first world country. So to say, if the USA and Somalia were to be taken as two different states, both have equal sovereign rights.
Of course. But is it actually the reality as well, Sahan? Now, theoretically, yes. Now, in the domestic context, different classes of people have different, they might have different rights, but by and large, as we said, the law is the same. But still, there are differences. There are differences appreciated by the judicial system itself. But in the international context, as you said, all countries are equal. But are they actually equal?
Not really. Because if you look at how things have been unfolding in the world, like up until, let's say, from the Second World War, after the Second World War, you can see that a lot of damage has been done by the US. Now, US has been considered the most powerful country in the world, mainly because of their military power and the Bretton Woods Agreement. If you don't know what that is, the Bretton Woods Conference was held in 1944, where they signed an agreement to have the US dollar as the world reserve currency. And also, if you look at it, 44 countries agreed to make the IMF and the World Bank. After that, the US had immense amount of power, economic power, and even military power to intimidate smaller countries. Now Siddharth, I just prepared a small list of countries that the United States has affected ever since the Second World War.
So before we go there, so the point you're trying to make is that although we say that all countries are equally sovereign on paper, in reality that is not really the case. They are equally sovereign, of course, yes, but the actual power divides these countries. The actual power they wield divides these countries. So that's why we have first world countries, we have developing countries, then we have middle class or somewhat developed countries. So we have various classifications which we give, and based on these classifications, the power they exercise in the global arena is also very different. So that is, I think, so just to close this discussion here, these are the main differences that we see between domestic law and public international law. Yes, now we will get into what you were about to say.
Yeah, now basically, I am going to show you how like the world order was. Now, emphasis on was, because this is not the same as it is now. If you really look at it, earlier the United States had immense, even now they have immense military power, but their economic power has changed. Before, after the Second World War, their economic power grew immensely, and they used this economic power and military power to basically bully smaller countries into, getting what they want, getting their way of things. Now, this is a small list I prepared. Basically, not all of the countries, part of the countries that were affected by the US. post World War II. If you take Korea and China, during the Korean War in the 50s, Vietnam, Laos, Cambodia, 60s and 70s during the Vietnam War, the Middle East, not to mention Iran, Iraq,
Of course.
Afghanistan,
And the Gulf War,
Gulf
especially
War, especially,
in the
yes,
1980s, I believe.
1980s. And you have Africa, Somalia, Libya, the Belgian Congo, and then South America, Nicaragua, Panama, Guatemala, Cuba. Now, this is not a small list,
Yeah,
and
exactly.
the list is even larger if you really look into the research. Now, that is because the US had so much of economic power. How did they come to this point of being able to believe? Why did nobody else do anything about it?
Well, it's partially because of the history itself, right? I think it goes back to the period of world wars, right? So the world wars, if you really look at the world wars, Sahan, you will see that USA was by and large unaffected by these world wars. However, the rest of the world was, especially Europe.
Europe.
So all the Europe's resources were exhausted at the end of these world wars. So who funded then these with ammunition and with so? So America was doing really well at this time. They were mass producing a lot of goods,
Good.
including food, and all these food and other supplies were all sent to these European countries and all the other countries, including Asia, by the US. So they had this economic sort of chain and arrangement built
A
by
sort of
the
a
end of
monopoly, if you.
sort of a monopoly. So and because they were not affected due to the world wars, at the end of World War II, the natural superpower to come out of the world wars was the US, and of course, not to mention the scientific and academic research they were doing. So that was also at its best. If you look at the 1800s, 1900s,
Hundreds.
so all these combined together, we naturally saw US emerging as a superpower at the end of World War II. So, which is, of course, there are for and against arguments for this. Some say that this is good, that some country came up as the superpower. Maybe that is good as well. We will discuss in the future. But for now, that is how this superpower came into being.
But is it always the same? Does something stay the same all the time? Not really. We've seen it in history where one nation or one side to say comes up in power, and it's always a cycle, right? It's always a
Yes,
cycle. Somebody rises to power, they start losing power, and then they become absolutely nobody. If you look at the Romans, Spartans,
exactly.
you see their civilization growing up to its peak and then falling down.
So even Sri Lanka for that
Even,
matter. Now we talk
of
about
course,
how we were great
great.
good 2-3 thousand years ago, but we are not the same now. Apparently, we had supplied rice to a broader part of the whole world back then, as per
I think
some of
even
the historic
recently, I think
records.
not about 30 years back, even during the
Yes,
Civil War, we were doing much better than we are
better. So
now.
now economically we are not doing that great. So of course this is a cycle. This might change, and we see this happening in Asia as well. So in Asia also certain countries which used to be superpowers or like countries are not doing so great now. But who knows, in the next 30-40 years things might change.
But the world order is changing now. If you look recently, by the time we are recording this video, the BRICS alliance was newly formed about 2 months back. The BRICS alliance, if you don't know what that is, it's an alliance between Brazil, Russia, India, China, and South Africa, and it is mainly for to change the currency. They want to change the reserve currency from the US dollar to something else. Preferably, they are all stockpiling gold. So we can get a hint from it, might be gold. But however, now, is this the only change we are looking at?
No, definitely not.
If you look at Saudi Arabia and how their behavior was during that course of time, Saudi Arabia, historically known for supporting the US and being all buddy buddy with the US, is now turning towards China. And why has this been like a sudden thing? It really wasn't. If you look at history, while America was threatening countries and sort of bullying countries into submission, China has been using a very diplomatic approach in terms of brokering deals, brokering trade agreements, loans, especially even for a country like us. Like they have given us loans. So they have been making good relations without using firearms. So this is usually preferable if somebody is going to bully you into submission versus somebody who's going to be like, okay, look, I can get you a better deal on this, how about we be friends? So obviously China has been developing this for a few years now, and now they have come to the point of having to control the major economic decisions in the world, even at OPEC, which China, by the way, is not necessarily a part of. If you don't know what OPEC is, it's the Organization of Petroleum Exporting Countries. which mostly consists of Middle Eastern countries and Russia.
And that is where the bulk of the wealth is in the
Is
world. Of course, now that is also changing. So many people say that data is the new gold or wealth. So that also will change. These economics will change, world economics. So all these things you see that this is what we wanted to show through this discussion is that public international law is a very, very dynamic subject. It is changing as we speak. It's not like any other subject, it doesn't stay stagnant for ages. For example, now in 5 years' time from now, we might be talking of something completely different when it comes to public international law. But as things are, this is how dynamic international law is.
And if you look at the domestic law, it changes over a period of time, and it's a long, lengthy process. But if you check international law, Russia invaded Russia invaded Ukraine overnight, and everything changed.
Everything.
We had sanctions. We had people asking for a General Assembly refugees, General Assembly resolutions, like they wanted a resolution from the Security Council to get involved. Now, so much changed overnight. That doesn't happen in domestic.
No, not at all. Now look at Sri Lanka. How far we have been trying to do certain basic reforms in our laws. We still haven't been able to. We are debating, changing. So of course there are a lot of concerns involved, but still we have not really been able to drive quick change in our domestic system. So that is how it is. But that's not only in Sri Lanka. If you look at any country for that matter, this problem is there. But that is not the same when it comes to international law, because laws are made as we speak. As we speak. Because why? The last segment of our discussion today is actually that on this, where can we find international law?
I think international law mostly stems from the thing you should appreciate is that domestic law is there in statutes or in some sort of document.
So it's all written down.
It's all written
So
down.
when you are changing something, you have to look at everything that is written down and then make sure that whatever change that you are going to bring also complies with everything that was written down before.
So that everything that goes along with it.
Of course. So that is why this process of changing domestic law is somewhat complex and lengthy.
That if you really look at it, where are public international laws? Where can we find it?
Yeah, actually, Sahan, it's very abstract. No one knows where you can find international law. Well, of course, there is a small reference point in the statute of the ICJ which lays down 5 sources of international law, but that is just a guideline. So if we are to just give a basic introduction to those 5 sources, so one is treaties, where these are agreements countries sign among themselves. Then the second one, most important, is customary international law. So these are customs. Where are customs written down? Customs are not written down anywhere. Now, for example, when there's a visiting head of state, how that visiting head of state should be greeted, that is not written down. We just do it as a custom. Sri Lanka does it and India does it. So based on what India does, Pakistan might do it. Based on what Pakistan does, some other country might do it. So that is how it goes. So over time, this has become a complete custom.
It's like you do something when somebody comes for the first time, or when you are doing trade for the first time, or some agreement is going to happen for the first time. You do something. If you like it, you want to keep that, right? You want to do it again.
Exactly.
And then that is how customary international law is made.
Comes into the picture. So that is the second source. Then we have general principles of law. So what are these general principles? Now the domestic principles which have been adopted in the international arena. Now that is also abstract. Now for example, the law relating to companies. Now where we talk about the corporate will and all of that. So some of the international judgments have recognized these principles. But then again, where can we find those in a definite sense? We can't. So it's based on a case by case basis. Then of course, another source mentioned in this article 38 of the statute of ICJ are these jurists' opinions. So this is again very abstract, right? So there might be so many individuals who can be considered as jurists. So what they have written constitutes international law sometimes.
And then you again have to consider what countries might think. Now, one country might not agree with something.
Exactly.
A majority of countries, don't agree with. Yeah. Now, if you simply look at North Korea and their approach with most treaties, they have simply just refused.
Exactly.
And they have not been a part.
I don't think they bother about this list of sources at all. They have their own version of international law. So that is how this international arena works. So I think that is something that we have to recognize and acknowledge as well, because that is the nature of international law. So then, Sahan, this next question which I'm going to ask is based on that. So can we then really call this a law?
I think we can.
Mhm.
Mainly because now, obviously, since like we discussed earlier, there's no central body governing
Exactly.
these laws. But the fact that we have international laws and we have been having for like thousands of years is because we want to keep peace, or at
Peace.
least relative
Exactly.
peace
Exactly.
between nations. And it's important that we find common ground. Because of it, that is why international law is so prevalent. Like
Yes.
if it wasn't good, it wouldn't last this long.
Exactly.
Most countries agree upon certain rules, agree upon certain regulations, treaties, or to say even small agreements. That is because it is valid and it will basically keep them
At bay.
at bay
Yes.
without being at each other's throats, to put it very
Yes.
simply.
And also, Sahan, now we forget one, we conveniently forget this aspect when we talk of international law. Now we have all these agreements, trade agreements, and all of that, which have made our lives so much easier. Now
Yeah.
we have a film releasing in the US today. How do we get it tomorrow in Sri Lanka? That is because all these laws have been put in place where trade can happen so freely, easily, where taxes can be sorted out easily. So this was not the case 200-300 years ago.
And
All
if you
right.
look at something more diabolical, now we have ways to punish people who have committed grievous crimes,
Yes.
slavery, genocide. This wasn't the case like
Exactly.
100,
So
200 years
if you
ago.
look at slavery about 500-600 years ago, slavery was something perfectly legal. Now it is not practiced anywhere in the world, I believe. And if someone practices it, there are very serious punishments. So these we have been able to come to these agreements thanks to international law.
International law.
So therefore, I think it is wrong to say that international law is not law, because this discussion is had by and large, and some people are of the opinion that international law, there is nothing called international law, and that these are just international politics. Yes, of course they are politics, but aren't politics a part of
Of
law
law,
itself?
and doesn't it play a bigger part? Doesn't it
Exactly.
support a bigger picture?
Bigger
So,
picture. Because if it was mere politics, we won't have these agreements and common ground and consensus among these countries. So therefore, it's a step further than politics and than mere politics. So there we can say that this international legal framework is there now. So how countries follow it and what are the exceptional situations, those are fine. We can discuss those later. But the majority of the countries have agreed to follow this. The best example is the UN. UN has more than 90% of the countries in the world as members. So we saw this now, especially during COVID, how fast the responses were. When the vaccines were given, all the countries got them, within a few couple of months.
and I think everybody talks about international law in the sense of like the doom and gloom, how it's supposed to stop wars, but we never appreciate how
Exactly.
fast it solves problems, or at
Exactly.
least tries to like
Address
attempts
these problems.
addresses these.
Of course, there are shortcomings which we will talk about, but nevertheless, I think we have to appreciate that international law has done so much good to the world, and that it is something that we all need to know about as well as citizens, because today in today's world we are all global citizens. I am no more only a citizen of Sri
Sri
Lanka.
Lanka.
We are all global citizens. We are all in this one global atmosphere, especially due to the internet and all these other advances. So therefore, we all need to be aware of public international law, international law at large, and that will be our goal. Our goal will be to educate you on this subject. So
and
I
we
think yes,
and we will be coming forward with more episodes with different topics, mainly supporting to the academic side of things, and we will try our best to
of
give you
course.
as much information as we can in the future.
Yes, and just one more note before we close today's discussion. So our series will be by and large based on public international law courses, which
Courses.
are available especially in so many degrees around the world, degree programs, and we will base our discussion on those lines so that students who are uh, watching these episodes can get those information
Information.
as well, and then they can progress in their studies. So today, just to give you a summary, Sahan, so we discussed about what public international law is. We had a basic definition, then we looked at the differences of private international law and public international law. Then we looked at the differences between domestic law and public international law, and then we looked at the evolution of international law and how dynamic it is. And finally, we looked at the different sources where we can find public international law. Of course, we will be expanding on these subjects and talking about these in the future as well. So thank you very much for joining us. We wish you all the best and see you in the next episode.
And make sure to like this video. And if you have any questions, drop them in the comment box. We will answer them as soon as we can. And make sure to subscribe to the channel so you can get notifications on when we post new episodes. Thank you.